Thank you. So, to the officials, we know that I want to, excuse me, I want to make this less abstract for the time being, because we know in the context of the last 2 years, there have been a number of protests on Middle Eastern politics in communities across the country. Let's say a listed terrorist entity claims as a symbol the keffiyeh, and this becomes a symbol that's very associated with a listed entity. Would a keffiyeh be viewed, or could it be viewed under this legislation as a hate symbol?
So thank you for your question. Taking a step back, we'd have to look back on, it's always a factual analysis, correct? And so the test here established in the provision would be, is it principally used or associated with? And so that would be, again, showing there had to be a close nexus between the group, the listed group, and the symbol. I can't provide a response as to yes or no whether that symbol would be associated. It really is a determination, again, for law enforcement based on available evidence, and I think that's as far as I can take it.
But by your answer, you're now saying that there would be a gray area where that could be. Because you can't say no, you're basically saying that a keffiyeh could be under this hate symbol if there was a listed entity that had associated itself with that symbol.
So if, based on available evidence, the facts at hand, it would be demonstrated that that symbol is principally used by and associated with the listed entity, and that's only a determination that can be made by law enforcement and prosecutors after a full investigation. Perhaps, but it's not a symbol. I cannot say today whether factually that is principally used by or associated with a listed entity. That nexus is a factual determination.
Iran has been acknowledged as a state sponsor of terror. Could waving an Iranian flag attract the same scrutiny? Could it be viewed as a hate symbol? Sorry, that was to the officials.
Can you repeat the question? Sorry.
Yeah, so Iran has been acknowledged as a state sponsor of terror. Could an Iranian flag be captured by this definition as a hate symbol?
So Iran is not a listed entity under the terrorism listing regime, under the criminal code.
So when we talk about like symbols, and I realize we are discussing one particular amendment here, but we have to look at various points C-9 in its totality. So if you'll indulge me, Chair, I do have to ask about other parts of the bill here, such as
Can I just interrupt you for 1 sec? There's a lot of conversations going on around the room, so I'm having trouble hearing Mr. Lawton and the witness, so if people don't mind. Go ahead, Mr. Lawton, sorry.
Okay, just come back.
So, sorry, we have to look at other aspects of Bill C-9 here, in particular the removal or potential removal of Attorney General consent for laying charges. And the reason I bring that up is because you, in your previous answer, Ms. Breeze, mentioned law enforcement discretion as being a key part of this. So how do we, and if this falls outside of what the Department of Justice is able to comment on, I understand, but how do we expect law enforcement to make these calls? Sometimes this comes down to, as Mr. Baber alluded to, nuances in the Arabic language that might not be known. Sometimes it comes down to, very technical details. In some cases, there is complexity to what is on the list of terror entities in the first place. So I'm just wondering if you could explain how these things would intersect with this section, and with that in mind, why we're talking about trying to remove ambiguity here.
Thank you for the question. So caveating, this is not my expertise. I'm not in law enforcement. But we would assume that police have tools. They have training to be able to identify. You have special counterterrorism units, for example. And so there are tools even publicly available, databases of symbols. So again, relying on that expertise of the police, their tools, their knowledge, this is how that factual determination would be made. And I would also like to always bring it back to whatever the symbol is. If you've established that the symbol meets the definition in the offense. Again, it all has to be considered within the broader offense. Again, the willful promotion of hatred against an identifiable group.
So we heard testimony from, I can't recall her names precisely, but it was a lawyer with the Canadian Civil Liberties Association, in which she posited that this section, unamended, basically amounts to a strict liability offense, where the act of displaying the symbol itself, irrespective of motive, is going to be an offense. And I just want to, for clarity here, I'll read the section in question here. We are talking about page 2, lines, so page 1. Everyone commits an offense who willfully promotes hatred against any identifiable group by displaying in any public place. Now, the Canadian Civil Liberties Association's position on this was that the wording of this suggests that by displaying, that is in and of itself sufficient to say that hatred is being willfully promoted. What is your view on that?
Thanks for the question. I would respectfully disagree. I think it's quite clear that this offense, which, as you will see how it's structured resembles the existing willful promotion offense. The display of the symbol, it's to be understood within the broader context of someone who is intentionally, willfully promoting hatred against an identifiable group by displaying the symbol. That displaying of the symbol is the communication. So it is not a straight ban on symbols, nor is it criminalizing the mere display of symbols.
My last question, did you or anyone in your department advise the government for or against the section that Mr. Brock's amendment seeks to remove, specifically the wording of resembles a symbol? Did you advise for or against that in your counsel to the minister?
So our role is always to advise the minister on the criminal law and Bill C-9 as it goes through the parliamentary process. And so within that ambit, we continue to provide advice on all matters related to the bill.
So, sorry, are you claiming or disclaiming responsibility for that wording? You can blame the minister. I won't hold it against you.
What I will say without... What I will say is that our role is to provide advice to the minister on issues related to criminal law. The content of that advice is subject to solicitor-client privilege, and so we're not able to be more specific in communicating the advice that we do or do not give.
You are paid by Canadian taxpayers, correct?
We are.
Okay. Thank you.